The United States of America was a federation. The Constitution of the United States of America established a federal government in which the central government shared power with the states. How should that sharing work out? What was the ideal and what was the real? Ideally, the 13 states still saw themselves as independent, sovereign bodies. Under the Articles of Confederation, they had the legal right to say so. With the federal government, it became less and less clear. What would that sharing actually look like? Would the sharing land more on the side of the states, or would the sharing land more on the side of the central government? As the federal government's power expanded, states began arguing over who had more power, the federal government or the states. All of this came to a head with the nullification crises of the early 19th century. Nullification is the legal theory that a U.S. state has the right to nullify or invalidate any federal law that the state has deemed unconstitutional. The foundation of this was pretty simple. It was state sovereignty. That the 13 states who broke away from Great Britain remained sovereign and independent. That was the actual words in the Articles of Confederation. And even though the United States transformed into from a confederation to a federation, states still exerted or asserted their right to sovereignty. This was all in the name of states' rights, that states had rights that the federal government could not violate. The Constitution is pretty clear about federal authority, that laws made under the Constitution shall be the supreme law of the land. Supreme means top. It's the last say. That the Congress shall have the power to make all laws which shall be necessary and proper. This is right in line with what we've been talking about. Ideally, Congress should be limited. It should be judicious in how it exercises its power. But when faced with the situation, Congress, under the Constitution, has the authority to make laws which it shall deem necessary and proper. So if the House of Representatives passes a law, if the Senate agrees with the law, if the President signs it into law, and the Supreme Court decides that it's not violating the Constitution, then the federal government has that power to confront all situations which it deems necessary and proper. And the Supreme Court, what is its role? The judicial power shall extend in all cases in law and equity arising under this Constitution, the laws of the United States and treaties made or which shall be made under the authority. So if there's a question of law, the judicial power in all cases rests with the United States Supreme Court. Nullification wants to take that federal power and give it to the states. That even though the Constitution states the judicial power in all case of law and equity arising under this Constitution rests with the Supreme Court, states wanted to retain the sovereignty that they had under the Articles of Confederation. They wanted the right to nullify or invalidate federal laws that they disagreed with. And so instead of going to a federal court and arguing the case before the Supreme Court, states wanted to do this on their own, regardless of what their neighbors had to say. Nullification. The first time this legal theory was tested was under the Alien and Sedition Acts of 1798. A group called the Hamiltonian Republicans were in office. They were around Alexander Hamilton. They organized around him. They were in the presidency of George Washington. And as we've already seen, George Washington opposed the Revolutionary War in France. And so Hamiltonian Republicans, backed by George Washington, put laws to try to limit American interference in the French Revolutionary Wars. This was around neutrality. George Washington's position of neutrality did not sit well with the French. And so the French sent agitators into the United States to try to stir up sentiment against George Washington in favor of entering the French Revolutionary War. And so the Hamiltonian Republicans put into debate a Naturalization Act and got it through both houses of Congress. The Naturalization Act in 1798 expanded the time frame from naturalization of becoming a United States citizen from 5 to 14 years. Meaning if someone came from France, they wanted to become a United States citizen, instead of having to wait 5 years, they had to wait 14. This was meant to stop Europeans from coming into the United States, becoming American citizens, and trying to take charge of American democracy. Congress also passed an act concerning aliens. It authorized the president to deport any resident alien considered, quote, dangerous to the peace and safety of the United States. An act respecting alien enemies authorized the president to apprehend, deport resident aliens if their home countries were at war with the United States. All of this was directed at England and France. That if Englishmen came to the United States or Frenchmen came to the United States and they started acting against the interest of the United States of America as directed by the President of the United States, the President of the United States could remove them from the United States. This gave power to George Washington to arrest and deport foreigners at war with the United States. The Sedition Act took it even farther. The official title of this is an act for the punishment of certain crimes against the United States. That's pretty broad. What were those crimes? It made it a crime to publish, quote, false, scandalous, malicious writings against the government or its officials. The Jeffersonian Democrats that opposed the Hamiltonian Republicans were writing nasty things about George Washington and Alexander Hamilton. They used freedom of the press to make up false stories, to spread scandalous information, and to use malicious writings to try to undermine Hamilton and Washington. Congress, under the Hamiltonian Republicans, passed a law restricting freedom of the press. These three acts, known as the Alien and Sedition Acts, the act concerning aliens, the act respecting alien enemies, the Sedition Act, combined stirred up incredible opposition. That opposition was led by Thomas Jefferson and the Jeffersonian Democrats. The Jeffersonian Democrats based their criticism of the Alien Sedition Acts on the First and the 10th Amendment. The First Amendment's pretty obvious. There should be no law, Congress shall make no laws restricting freedom of speech, freedom of the press, freedom of assembly. These acts did just that. The 10th Amendment was another argument, that nowhere under the Constitution did Congress have the delegated powers to make such acts. And so because the Constitution did not delegate the power to the United States, the Constitution did not forbid it to the states, the power over alien residents in the United States then rested with the states, Jefferson argued. Both Kentucky and Virginia passed resolutions. Those resolutions stated that the Constitution was a compact among states, not people. That the states, because they wrote the Constitution, the states were superior to the federal government. Compact theory. That states came together to create the federal government, not people. And so the states, whensoever the general government assumes undelegated power, its acts are unauthoritative, void, and of no force. So Kentucky and Virginia passed resolutions stating that the federal Alien and Sedition Acts were null and void. They had no force in Kentucky and Virginia. If other states wanted to authorize the federal government to act within their states, then they could. But in Kentucky and in Virginia, they did not recognize federal sovereignty. They wanted a limited government. New Hampshire, on the other hand, took the other side. State legislatures are not the proper tribunals to determine the constitutionality of laws of the general government, the United States, the Washington government, the central government. The duty of such is the properly and exclusively confided in the judicial department. In other words, New Hampshire took the side of the federal government. If states like Kentucky and Virginia thought that the Alien Sedition Acts were unconstitutional, that they were expanding federal authority, then Kentucky and Virginia had to go to a federal court. They had to sue in a federal court, testify in a federal court, present their evidence in a federal court, and then appeal all the way to the Supreme Court. Kentucky and Virginia had no sovereignty. They had no right to simply nullify federal law. At this moment in American history, the nullification crisis passed with relatively small events. The election of 1800 settled the issue, or at least appeared to settle the issue at the moment, because Thomas Jefferson ran for and won the presidency of the United States, making the whole alien sedition argument null and void itself. In other words, the Jeffersonian Democrats took control of the United States federal government and then did not enforce the Alien Sedition Act, making the resolutions in Kentucky and Virginia obsolete. And so this issue over the question of nullification, did states have the right to nullify federal law, was simply put off until a later date. But it shows the conflict between the ideal, should power rest with the states, and the real, the need for the federal government to act as the supreme law of the land. In this case, it became a moot argument, because Jefferson's election meant that this debate didn't proceed any farther than it had in 1800, and it was put aside for the moment.